joining us, as well as the Nishith Desai team, to provide our quarterly media and entertainment overview. The idea of this event, this webinar, is for us to catch up on important activities in the media and entertainment space that have occurred over the last few months. We will have a short presentation by our experts with a few slides. We will share those slides afterwards, and then we will have a question and answer period. Let me begin by saying this webinar is being recorded. I do also want to give a shout out to a few of our leaders beyond our knowledge experts at Nishith Desai. I'm really pleased to have Ed DeSanto, who is a USIBC board member. Thank you, Ed, for joining. Really appreciate it. I also saw Jared.
Thank you, Jay. Good program coming up, I think.
Thank you, sir. I'd also like to thank Jared Doherty, who's one of our media and entertainment co-chairs. I saw Jared, so I want to thank you for joining as well. And I see a few of our knowledge experts as well. I see PLR Chambers, who helps lead our privacy work. And I also, if I've missed any of our leaders, I do apologize, we have a nice group today. So let's jump into it. I'm going to hand it over to the Nishith Desai team. Husefa is going to go ahead and introduce. If you could maximize those slides, Aparna, that would be great. And I'm going to hand over the microphone over to Husefa. Over to you all.
Yes, absolutely. Welcome all members, and thank you, Jay, for the context setting. I think this update is so very pertinent because we actually have a new law, which is going to impact gaming companies in India. And the way we've kind of split this update, it's into two halves. The first half, we're actually going to spend time in relation to what is the update and the amendment which has happened from a gaming perspective in India, a gaming regulatory perspective in India, and specifically what are the important nuances from a cross-border perspective which need to get be factored from an ongoing perspective. The second half of the presentation is going to be split into three very interesting case laws. We've got some interesting jurisprudence. The first is how does courts in India look at foreign direct investments in India, specifically from a gaming company perspective, and where does the line from a gambling perspective be looked at from a foreign direct investment perspective. The second one is royalties for sound recordings and underlying works. This again becomes very relevant from a cross-border perspective for streaming platforms or any other content providers offering music. It could be a Spotify, YouTube, and so forth and so on. And last, it's from a content compliance perspective, specifically an interesting case from a age rating and a content rating perspective. So this is the overall context setting, and let me without further ado introduce Tanisha and Aparna, who are part of the Nishith Desai team. Tanisha leads the gaming practice of the firm, and Aparna leads the media and entertainment practice of the firm. I think let's just put the screen, Aparna, if you can put it on the slideshow so everybody can see it slightly bigger. I think it's not yet changed.
Oh, give me a second. I think there's some issue. Yeah.
Just give us 30 more seconds, and I think just from a how the first half is going to read, as I mentioned, Tanisha is going to speak on the updates which happened from a gaming law perspective. They came in the first week of April, so they're really less than a month old, and I think we're just getting started. So Jay, is it okay we just continue on this slide? I think
please do, and I'll go ahead and start. I'll take over on the slides.
So if we can,
Yeah.
Ayush.
There we go. Gaming slide. Can you see that, folks?
I think it's disappeared again.
Okay, let me do this. My apologies for the technical difficulties. And Aparna, if you stop sharing, Aparna, I think that I can go ahead and do this.
Yeah, I have stopped sharing.
Okay, great. So hopefully you all can see this now. Somebody can confirm that.
It
Yes,
is
I can see.
perfect.
thanks.
So over to
Perfect.
you, over to you, Tanisha, to kind
Great.
of give us the context setting on the amendments which happened less than a month back.
Great, great. Thanks a lot for the introduction, Josefa, and hi, everybody. Thanks for joining. So, without further ado, I think in the last edition of this quarterly webinar, which we had discussed the amendments to the IT rules to regulate online gaming activities when they were still in a proposal stage. However, the final draft of the rules have come out and are effective as of date. And there are, some departures from the proposed draft that we had seen earlier in January. I will just, for the benefit of everyone who didn't attend the previous session, I'll just take a step back and do some context setting. So currently, betting and gambling is regulated at a state level in India, and each state has its own laws to regulate these activities. Most of these state laws exclude what we call games of skill, which is games where there is a preponderance of skill over chance. Now, what was happening was that there was a lot of business uncertainty which was being created in the industry because different states were taking different views on which game is a game of skill or which is not a game of skill. So the ask for the industry for several years has been for one single central law to give them that business certainty in India. So the government did because the online gaming industry has been growing leaps and bounds in the last few years. The government really has been taking steps to encourage this industry. And at the start of this year, they began taking several steps to bring in that business certainty for this industry. So earlier this year, the Ministry of IT, which is the MeitY, was made in charge of the online gaming industry, and the Minister of Sports was put in charge of esports. So the appointment of the central regulators was sort of the first indication that there would be central regulations forthcoming for this industry. Now, there were amendments to the IT rules which were introduced a couple of weeks ago, as Josefa mentioned, which brought about central regulations for this industry. Now, I'll just give you a quick overview of how these rules work, just on a very broad level, and this is in keeping with the government's promise to reduce prescriptive laws for for the IT industry. They have basically created a very light touch co-regulatory framework between the industry self-regulatory bodies and the government, whereas the bulk of the regulation and oversight of the industry is left at the hands of the self-regulatory body, right? Now, in terms of what games are regulated, right? The primary onus of obligations and the bulk of the regulations are in respect of real money games. That's games where there is a deposit in terms of cash or kind, and there's winnings in terms of cash and kind, right? There are some limited compliances applicable even for casual games. That's free to play games where there is no money in and no money out. However, very interestingly, MeitY has sort of retained the power to extend some of the obligations applicable even to real money games for free to play games as well, on certain grounds. And one of those grounds is user harms. So we could see more stringent regulations even for free to play games if MeitY believes that it is causing user harm, or on other grounds as well. Now, coming to some of the obligations applicable to online gaming operators offering games, like I said, which are real money games where there is a deposit and winnings, right? So one is that the the operator would need to go to a designated self-regulatory body, and there is a mechanism for self-regulatory bodies to get designated under the rules. So they will have to go to the self-regulatory body with their game format, and the self-regulatory body will sort of evaluate the game format and register the game format. So the first key compliance is membership with the self-regulatory body and registration of the game. Now, what we understand from our discussions with because there are already self-regulatory bodies functioning, which will go and get designated under the rules. What we understand from them is that the self-regulatory bodies will still require legal opinions from law firms to say that the game format is a game of skill. So although the law doesn't call out skill or chance anywhere, it seems that only games of skill will get registered even under the new central laws. There are a host of player protection measures which have come out under the new rules. The operators have to make certain disclosures. There is a grievance redressal mechanism put in place through which the user can complain to the gaming operator, and if that complaint is not resolved, there is an appeal process to a grievance appellate committee as well. Uh, there are some prohibitions on third party financing. So operators are prohibited from providing financing to users to sort of discourage them from playing beyond their means. There is and I'll just take a step and elaborate on this. There is a very stringent player KYC requirement which has been put up under these rules. Now, I think those of you who attended the last edition of this webinar, you would recall that the industry had a heavy pushback on the KYC obligations which were being proposed under the new rules, because the KYC obligations for the gaming operators were akin to the KYC obligations which are in place for NBFCs and banks and highly regulated entities, right? They had sought to apply the RBI's KYC norms applicable to those types of entities, even to online gaming operators. And the second issue was that the KYC obligations under the proposed rules were at the time of the account creation with the operator, right? And there were operators which said that we allow players to play free games for a while, and we don't want to create that kind of user friction. What was being considered under the during the policy consultations, etc., during the intervening period between the proposed amendments and the final draft which we have here, was that there would be a graded KYC approach, whereas the amount of KYC which the operator would be obligated to carry out would be proportionate to the amount of funds that were being handled by the operator, which is very similar to the obligations applicable on PPI wallets in India today. However, unfortunately, that same stringent KYC has been made applicable even under the final version of the rules. But they have changed the trigger for the KYC from account creation to at the time the user puts in the first deposit. So that has been some sort of relief for the industry. I think Jay, we can move on to the next slide. Right. So now, I'll just point out, some of the issues and, implementation measures which still, remain to be seen under the new rules. And, we expect that these things will be developed over the next few times. There is the draft has not come in, ideal action. I mean, in an ideal form. There were some drafting ambiguities, in some definitions, even in respect of the obligations which are applicable to free to play games versus the obligations which are applicable to real money games. So there is some drafting ambiguity, though we do expect that the IT ministry will come out with FAQs, Q&A to clarify those issues, and we should be able to iron out those issues fairly easily. The bigger issue was that the purpose of this rule was really to reduce the state-wise uncertainty, right? Was to replace the state-wise laws with one central law which everyone was following, and that would give business certainty to the operators. However, these rules do not replace the state-wise laws, and the center can't usurp the state's jurisdiction under the constitution to even legislate on betting and gambling activities. So the state-wise uncertainty and the state-specific nature of the laws is continuing. And we have seen, a very recent example in the state of Tamil Nadu, where notwithstanding these rules being introduced, the state of Tamil Nadu has gone ahead and enacted laws to ban even games of skill like rummy and poker. Um, so, I think, the question there is really a matter of socializing the law enough with the states to show them that, the issues which they had in terms of consumer protection, etc., are already being sort of addressed under this framework. So that is, something which remains to be seen. Uh, like I mentioned at the beginning of this presentation, was the crux of the implementation has been left to the hands of the self-regulatory body. And, there are a couple of items which the SRB will really have to, evolve. One is, determining whether a game is a game of skill or chance. What's been happening now is, as I mentioned, the law firms were giving legal opinions. The operators were providing, data to sort of show that their game format is a game of skill. So we'll see, what is the benchmark which is evolved, which will even allow the operators to sort of speedily release their game. One of the great features of this rule is that the self-regulatory bodies have been given the power to allow the temporary release of a game for 3 months till such time as they register the game, and pursuant to which they will carry out the formal verification of the game, and then finally decide whether to allow its release or not. So this enables platforms that say want to launch like several games in a week not to have to wait for that verification to sort of release their game. As I mentioned, KYC remains an issue, though what we do understand is that the SRBs are in consultation, with the ministry to really push them to try and allow, a graded KYC approach for the industry. Also, there were some features of the proposed amendments which were not finally introduced in the final version of the law that we see. One of the thorny issues was, getting a random number generation and no bot certificate, which is conspicuously be overly prescriptive under the rules, and these sort of obligations will probably come out in the self-regulatory body's charters. Another issue which is not sort of related to these rules is specific is the GST conundrum which is facing the industry. What's been happening right now, up until now, and there are court judgments to support this view as well, was that gaming operators were paying 18% GST on their commission amount. Whereas we have seen, some scattered enforcement action, GST notices being given even to gaming operators, demanding that 28% GST be paid on the entire pooled amount of players. The GST Council, which was constituted to sort of evaluate the GST applicable to this industry, is still mulling over what the GST framework should be. So, while there have been several steps towards certainty, even the TDS position has been clarified for the industry in the budget announcement. GST is sort of the last frontier, the last sort of thing which needs to be clarified for this industry. So, that is our update on the IT amendment rules to regulate the online gaming industry. I'll just quickly move over, and Jay, you can move the slide. I'll just quickly move over to one, sort of very interesting Bombay High Court case that we have seen from one of my favorite judges. So just to give you a background, right, under the FDI policy in India, which is the Foreign Direct Investment Policy of India, FDI and entities involved in betting and gambling or foreign technology collaborations with entities involved in betting and gambling is prohibited, right? But there was always ambiguity as to what amounts to betting and gambling from an FDI policy perspective, right? Because these terms have, were not defined under the FDI policy. So the industry was sort of, relying on the gaming, the state-wise gaming laws to sort of understand and interpret these terms even from an FDI policy perspective as well. However, in this very interesting judgment, the Bombay High Court has sort of clarified, sort of interpreted the terms betting and gambling even from an FDI policy perspective as well. So just to give you a background of this matter, right? So this sort of entity was offering real money, rummy and fantasy sports, and free to play versions of the other two games, which is ultimate theme. Sorry, not free to play games. Let me which is ultimate teen patti and call it right. Now there were some I think some minor reporting delays etc by this entity, which had significant foreign investment and over 96% foreign shareholding. So this entity sort of filed a compounding application with the RBI to sort of resolve those minor non-compliances. And that compounding application basically has remained in abeyance for 8 years, right? I think it was between 2012 to 2020, where there was a lot of back and forth between RBI and this entity, where RBI said that they would need a clarification from the DPIIT as to the eligibility of this entity to receive FTI in the first place. So I think this entity had made several applications to the DPIIT, but they were not, forthcoming with their reply, right? And in their representations, they presumably sort of demonstrated that their game formats did not amount to betting and gambling under the FTI policy. Now, when there was no resolution of this, the entity sort of filed a petition before the Bombay High Court, seeking directions from the court to the RBI to proceed with its compounding application, right? Now, what's very interesting is the not just the court's holding, but the affidavits that were filed by the DPIIT and the RBI in this matter, right? What the DPIIT basically said was that the issue was that with the latter two games. Now, there are several High Court and Supreme Court judgments holding rummy and fantasy sports to be a game of skill. So DPIIT did not raise any issues, with these two game formats. Their issue was with Ultimate Teen Patti and Call It Right, which in their view was a game of skill. And there is an observation in one Supreme Court order also calling Teen Patti as a game of skill. However, what DPIIT did not do was make any inquiries with the petitioner, trying to find out, are these games free to play, or are there rewards being given in these games? There was no sort of inquiries made by DPIIT, right? So they took issue with these two games, and they said that offering of these two games amounts to betting and gambling because it is a game of these two games are a game of chance, and therefore this entity was not eligible to receive FTI. What RBI said was, and this is very interesting, the RBI said was that, look, we are not going to look into the legality of your business or whether it amounts to betting or gambling one way or the other. We just want some regulator, some authority to sort of look at it, and then we will proceed with the compounding application one way or the other. Now, what the court did was, they looked at the Supreme Court jurisprudence on this issue as to what amounts to gambling, right? And there is a Supreme Court ruling which says that for an activity to amount to gambling, even under the state-wise gaming laws, it has to be both a game of chance and it has to be for money. There must be money in, and there must be a chance of a reward. So applying the Supreme Court reasoning, the court basically said that because these games did not involve a reward, it did not amount to betting and gambling under the FTI policy, and therefore they directed the RBI to proceed with the petitioner's compounding application. Now, this is the first High Court case which has really interpreted the terms betting and gambling even from an FTI policy perspective as well. And this is the first time that we have seen even the regulator, the DPIIT, applying the High Court jurisprudence and the Indian court jurisprudence while interpreting a term even from a policy perspective as well. So this, the takeaway here is that for investors now looking to invest in gaming companies in India, there is some clarity on, the FTI prohibitions and what types of games you can, how the regulator is likely to look at whether games are eligible for investment or not. So that is, the case that I thought we'd discuss. I'll pause here to see if, anyone has any questions on anything I've said so far. And then, Aparna can take over for the second half of our presentation.
I have two questions for you. So one, if the GSTA Council changes the fee, it's conceivable that a lot of companies would have a lot of back payments. Is that an accurate assessment? And could that really undermine or result in the collapse of some companies that have large unexpected tax bills?
No, I don't think that would be the. I mean, to begin with, we don't believe that the position taken by the GST Council will be different from the position that's taken by the industry so far. Because if you see the way these companies work, right, they are providing a service in terms of a platform for players to play against each other, and these platforms are only offering games of skill. So it shouldn't be that they are the ones playing against. They are not the ones playing essentially, right? They are just providing a service in terms of the platform. So logically, there is no reason why the council should take a different view than that has been taken from the industry so far. So I don't foresee that really as a consequence.
Correct, thank you. And an overall question, since the guidelines have come out and maybe there's some clarity in FDI rules, have you seen any changes in market dynamics or interest in this sector? How has these rules impacted the real business of e-gaming in India, or is it too early to tell?
So it is a bit early to tell, but I can tell you that even notwithstanding these rules, the kind of investments we've seen in this industry in the last few years, it's one of the fastest growing industries in India. It's India's sunrise sector. And that's actually why the government, said that this industry has now become too big for us to ignore. And they came out with a host of these measures, right? So notwithstanding these rules, in any case, there was a lot of investment. We were seeing Indian gaming companies achieving unicorn status already, startups. But I do foresee that the already accelerated growth of this industry will increase manifold even with the business certainty that's brought in through the new IT rules.
Thank you. Do our members have any questions? You can raise your hands now or put a question into the chat. And while we're waiting for our first question, just from your experience, when you look at these games, I think of India's, larger media market. Are you seeing them as being in sort of the general English content category, or are you seeing a lot of either Hindi languages or vernacular that might suggest, more localized startups, smaller scale, or are you seeing this really sort of tracking with what you might see, globally?
Sorry, I think there was some audio issue on my end. Could you repeat that, Jay?
Sure. So, in terms of the market, are a lot of these gaming companies that you're seeing, are they in English language? Are they tracking to the international community? Or are you seeing a lot of Hindi and vernacular languages that might suggest a lot of localized startup or entrepreneurs?
No, so I think most of these platforms are English English medium, but there is a I mean, I think they have functions through which you can translate the content into local languages as well. I'd really, it depends platform to platform. But we are seeing that there is a lot of localized content being served to the Indian audiences in terms of the game, like even the games themselves, right? We have seen some very interesting platforms where the game format is derived from, with appropriate modifications to make it skill based. It's derived from games which Indians have been playing since we were children, right? Like casual board games, and we see card games which are maybe not popular in other parts of the world, like Rummy, but it's a very popular sort of Indian pastime. And as in the case of this petitioner, the game of Teen Patti as well, which they were offering for free. But we are seeing localized contents in terms of the game formats itself. Just your question reminded me of one other aspect which I thought I'll quickly delve upon. In terms of foreign operators offering the game formats in India, right? Currently, under our exchange control laws, there is a prohibition on remittances by Indian users to participate in any gaming activity offshore, right? So, because of this prohibition, it was not possible for there to be it's not possible for there to be global liquidity between Indian players and foreign players, right? What another aspect, which the industry is sort of considering is to whether they will allow, and sorry, I mean the SRBs are considering is whether to allow foreign gaming operators offering games of skill to come to India, comply with the IT rules, become members of the self-regulatory body, and therefore offer their games in India. But that market, of course, will only be restricted to games of skill.
Thank you.
Some of the other popular foreign games that we say, sports betting, etc., are not, at least in the short to medium term, will not be able to offer their game formats in India.
Great, thanks.
And
I want to see
think
if,
just
I wanted to
yeah.
see if Bikas and Naveen wanted to come on and ask their questions.
Yeah, hi, thanks, Jay. So, I mean, no, it's not a question basically. I mean, it's more of a comment to your question. So, as Tanisha pointed out, I'll just like to add to that. As far as number one, local content is concerned, the IT ministry and especially the Minister of State, and I know for sure because he used to have those meetings with the industry association concerned. I mean, they look at it from a very positive angle, from a tech perspective, in the sense that they feel that it's a huge potential, not just for development of games, which can be exported out of India, just like any other sector, and a matter of huge employment. So they have a bit of a positive angle. And as Tanisha pointed out, it's really grown big. As far as I know, there's a lot of gaming content which is being developed in regional languages also, primarily from a market potential perspective. So that was one comment that I wanted to just keep you updated, because the government felt that, yes, it's a great potential area, but then obviously there is a social obligation that the government has to the people at large or to the citizens, is the way they, the constitution says that alcohol, as per constitution, is not to be allowed within the country. It's a prohibited state as per the constitution, by the way, Jay. But yet it has put it into a list where the states have been given the powers that you can regulate it and do it, and it's a huge revenue churner. So, barring a few states, everybody does that. Probably they were wanting to take something of that sort of approach. Number two. And number three, the complexity, Jay, just for your making it simpler for you to understand and for other participants, is what Aparna pointed out, is that at the moment, because it is not in the central list, states have the regulatory authority and everybody has been interpreting it in their own ways. And especially in the state of Tamil Nadu, it has often taken political hues. So those are some other nuances that you as a public policy expert may be able to understand, going beyond just the legal aspects of it. Thank you.
Thank you very much. Great. We got a couple of other questions. I'm going to call Subi, if you want to share your question, please.
Jay, I've posted it in chat as well. Tanisha, thank you for the overview. And I did want to say that, Jay, I don't know if a lot of people on the call have been very close to the issue. We've been involved since November 2020, and I think this is really the best place that we could be at. To your earlier question as well, it's already had a huge impact on investor sentiment, where regulatory certainty, and not just, the fact that you have MeitY as a line ministry, you've got guidelines, but we got light touched regulation, which was really, really important, because there were some quarters who were asking for licensing. That would have been a disaster. Tanisha, just one request, you talked about the judgment. That will be really helpful in the FDI issues. If that
Sure.
can be shared, that'll be very useful for all of us. Thank you, Jeff.
Sure.
Thanks. Thank you. And I know, Naveen, you've been very patient, and if you want to come and ask your questions, and then I'll go to Husefa.
As always, Jay. Thank you, Tanisha, for the presentation. Just a quick question in terms of your assessment on the definition of OGIs, whether it means a platform or it means a publisher, because there are many platforms who host a lot of games, but they're not the publishers. And the reason I'm asking this question is there are specific requirements apart from the fact that the online real money gamers have to register with the SRBs, but there are some obligation under point number 3 also indicate that the companies have to publish the terms and conditions, etc. So while we all await clarification from MeitY in the form of an FAQ possibly, but what's your take, whether it includes publisher or a platform, because platform does not owns the app actually and the games. Thank you so much.
Right. So, sure. So, as I mentioned, there are some drafting ambiguities in the rules, right? And one of the first issues is on the definition of OGI, which sort of presupposes these entities are intermediaries, right? Because it's defined as an intermediary that enables access to one or more online game. So, if you see our detailed hotline, maybe I'll request my colleague to post a link of our hotline on this chat, right? We had even pointed out this issue that basically there are a host of intermediaries which enable access to an online game, and not all of those are the publishers of the online game, right? You'll have an app store, you will have an social media platform on which there may be a clickable link to the game. So all of these intermediaries play a role in enabling access to the game. So that is definitely, as you correctly pointed out, one definitional issue, but we do understand that the intent of the definition is to capture only publishers of online games. Maybe this would be clarified in the FAQs which METI comes out with.
Thank you so much. Very helpful.
Thanks. Thanks. Vanita, why don't you ask your question, please?
Thank you, Jay. Thank you so much for Tanisha for giving us an overview. That's really helpful. I have a very silly question. I'm not from the gaming industry, but I know that a whole host of companies and brands run various types of competitions, which involve some sort of gaming, right? And may or may not include prizes in cash or in kind. There is a separate act that covers that, right? How does this act overlap with these rules overlap with that act? And is there a clarification that we may see coming in with respect to that? Thank you so much.
Sure. So I believe the act that you might be referring to, there is no actual standalone act which regulates free to play games. There are a smattering of different laws like the Prize Competitions Act, etc., which could have a bearing on a game format, provided it falls within the definition of those games. But to answer your question, games where there is no money in and no money out are treated as online games. Games where there is money in and money out are treated as real money games. For online games where there is no money in or no money out, there are very limited sort of compliances which are akin to a publisher of a game format under the rules, right? Like certain things need to be spelled out in the terms and conditions. If they get a takedown notice to take down that game, for example, if they believe that if it's believed that that game is causing user harm, right? Because we have seen instances even like the Blue Whale Challenge, etc., where there was a significant impact of that game on user harm. So the rules recognize now that the ministry may ask for takedown of even those types of free to play games as well. But there are very limited compliances for free to play games. However, METI has reserved the power to extend obligations applicable even to the real money games, certain obligations, for example, the obligation to get your game format verified, etc., even in respect of the free to play games, if they believe they need to do so on certain grounds. We have also seen, instances where certain gaming apps were blocked due to data sharing concerns with hostile countries, right? And those games also didn't involve money in or money out. So those are the types of consequence that we could see even for those types of games under the new rules.
Thank you. Husafa, you've been very patient, sir. Over to you.
No, I just wanted to make a couple of points, especially on the relevance of these rules and the growth of this sector, right? I think why so much of focus has been laid from a government is the simple reason is the growth of this industry. And I think I'll just make three data points here. That the internet penetration in India is at an all-time high. There are over 800 million connected users. Second, India is amongst the top 4 lowest internet data countries from a cost tariff perspective. So internet penetration is only going to increase. And the next is the most relevant. The social gaming industry has had the highest compound annual growth rate as compared to any other countries. And basis certain statistics, it's tipped to be over 400 million users between the age group of 15 to 35. So I think these 3-4 important factors, and considering the continued penetration on these 3 points, this sector is only going to increase, which is why the government is also taking cognizance of these facts. So I was just kind of responding to someone who mentioned that what is the growth and impact of this industry.
Great, thank you. All right, I think we've had our questions for this segment. Tanisha, you want to hand it over to your colleague, please?
Over to you, Aparna. Thanks for listening in, everyone.
Thanks, everyone. Thanks, Tanisha. So what I will be covering now is one. Actually, we have two important judgments to cover, but basis how much time we have, and because one of the judgments we've anyway covered in the monthly updates that we have, we will cover these. The first one is the very recent judgment. This is a good one for IPRS. This is a judgment wherein by the Bombay High Court, where the Bombay High Court has agreed that IPRS has a right to collect royalties on behalf of authors of underlying works for exploitation of sound recordings that contain those works. So this judgment has been passed in relation to sound recordings being exploited on radio stations. The defendants in these cases, in the two matters where the judgment has been passed, are two radio stations. One is Radio Tadka, one is Radio City. To just give everyone, before I get into what the judgment is about, I'll just very briefly discuss what has happened in relation to the law in this regard, and what has been the movement, and why this judgment is very important. Before that, IPRS is the Indian Performing Rights Society Limited. It is a registered copyright society under the Indian Copyright Act. It administers the rights of authors, composers, and publishers in relation to literary and musical works. To very simply put it, it basically looks after the rights of lyricists and music composers. So what has happened, and some of you may know this, we have the Copyright Act 1957. In 2012, there were significant amendments made to the Copyright Act, through which the law tried to clarify the fact that there will be a right for underlying work owners to continue to own royalties, even if they have assigned the works in which they've already assigned the works to, say, a producer. Jay, can you please move on to the next slide? So I'll very briefly discuss the amendments that came in, the relevant amendments that came in 2012. Very broadly speaking, 2012 amendments are not only in relation to these underlying rights and underlying works. There were various amendments made in 2012, but these are only some of the relevant ones that I'll be discussing. First are, these provisos were added in section 18. Very briefly, what these cover is that the section basically said that even if you have assigned your rights in a work, the author of the literary or musical work included in a cinematograph film, which is the first proviso, or in any musical work included in a sound recording, which is the second proviso, but not forming part of a cinematograph film also, they shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of the copyright for any utilization of such work. So these are the amendments that came into section 18. Jay, could you move on to the next slide? There were further amendments made to section 19, which basically clarified that no assignment of copyright in any work to make a cinematograph film shall affect the right of the author to claim equal share of royalties. Similarly, for a work, for any sound recording which does not form part of the copyright, a cinematograph film, the same amendment was brought in, that even though you've assigned copyright, it will not affect your right to claim royalties in relation to the work, which is the underlying work in such royalties. So now, Jay, you can move on to the next slide. Thanks. So since these amendments have come in, so just a brief background on what has been happening in the industry. Since these amendments have come in, there has still been a lot of IPRS has struggled, and there are various reports on this, has struggled to collect royalties on behalf of publishers and authors of literary works, musical works. There has been some gray area as to whether what exactly is the meaning of these amendments that have come in. In fact, in 2021, there was a decision by the Delhi High Court in the case of IPRS versus ENIL, which is what's mentioned on the screen right now. In this judgment, the court looked at the amended provisions and basically held that the amendments to the Copyright Act are only clarificatory in nature. They are not amending the position at all of the law. To state that what the amendments do not mean that once you assign copyright, you will still continue to get royalties. The court essentially held that once you assign copyright in these underlying works, you are not entitled to royalties, and any person who's exploiting a sound recording which includes these underlying works does not need to come to you, which is when I say you, to the authors of the underlying works, they do not need to come to you for a license, either authors or IPRS if IPRS is administering the rights. However, now the Bombay High Court, in this decision that we're discussing, now the Bombay High Court has disagreed with the Delhi High Court decision. What the Bombay High Court noted is that the Delhi High Court decision in fact dealt with suits that were filed prior to the 2012 amendments, and there was no question. The question of what exactly is the impact of the 2012 amendment should just not have been dealt with by the Delhi High Court. The Bombay High Court has also noted that the Delhi High Court has not, while passing the order, they have not considered the statement of objects and reasons of the 2012 amendments, which very clearly clarify the intent of making those amendments. And in fact, so one of the intent of the amendments is that there should be to clarify the rights of owners of underlying works, to give them the right of royalty, etc. Basis all of this, so the High Court, now the Bombay High Court, considered these aspects, considered the language in the amendments, and basis this, the Bombay High Court has now held that authors of literary and musical works are in fact entitled to royalties every time a sound recording containing their work is communicated to the public. One more question here was, is playing of the music on radio communication to the public? So the court has also noted that yes, when a song is played on radio, that is communication to the public. So what I'll do is, because we have some more time, I will go through the next decision. Jay, you can move on to the next slide. This we very briefly did discuss on the last month's monthly call, but because there was some interest with the members, we thought why not just deal with it in a little more detail to discuss, because and it does have a lot of impact on publishers, and also how platforms such as say YouTube or other platforms any actions that they should be taking in relation to content that's hosted on their platform. So this is the decision of the Delhi High Court in relation to a web series called College Romance. As some of you may have been on the call last time when we discussed that the Delhi High Court directed filing of an FIR against the producers, crew, and cast of this show on the ground that the web series, a particular episode of the web series contained vulgar and obscene language and obscene content. And while there was obscene content, sufficient measures were not taken under the digital media ethics code that the publisher needed to take to in relation to say age gating, age rating that they were supposed to do, which that was not done, and hence they should the direction of the court was to file an FIR. So as for background, very quickly, in September 2019, the Additional Chief Metropolitan Magistrate directed the Delhi police to register an FIR on grounds of obscenity under the IPC and also under the Information Technology Act, which provides punishment for publishing or transmitting of obscene content. After that, there was an appeal filed, and additional sessions judge also upheld the judgment of the ACMM. Thereafter, there were further appeals filed against the orders of the ASJ and the ACMM before the Delhi High Court. Next slide, please, Jay. So Delhi High Court did view certain episodes of the web series, and it found that some of the content did contain excessive swear words, and there was vulgar language, and noted that the content is likely to be violative of Section 67 of the IT Act, which provides punishment for publishing of or transmitting of obscene content. What the court noted is that TVF, which was a publisher of the content, they were in violation of the Digital Media Ethics Code because they had failed to do age rating. So mentioning that there was, this was only adult content. There was no warning or disclaimer in the content for any, the type of language being used, and there was no age gating, which basically the code provides that reasonable measures have to be taken to ensure that in case the content is such that it should not be viewed by people below a certain age. Measures need to be taken to ensure that such content is not available. But TVF had not taken any such measures. Next slide, please, Jay. So finally, basis this, the court directed, there were 3 directions, and some of them slightly problematic. I will discuss those in a minute. One is directed the court to register an FIR under the obscenity provisions of the IT Act. Secondly, the court noted that since the web series was posted on YouTube without any classification, court noted that YouTube should take certain remedial measures as per the law in this regard. And thirdly, the court directed MeitY to take steps to enforce the IT rules more strictly and make additional laws or rules in relation to obscene content being available on platforms. The one thing that I just want to point out here in this slide is that while the court said that YouTube should be taking remedial measures under the Digital Media Ethics Code, the obligation to age gate, age rate is only upon the publisher. It's not on the platform which is hosting that content, and therefore this direction may have been slightly misplaced. But I mean, one takeaway from this could be that any platform allowing publishers to host content should just make sure that there are options to age gate, age rate, so that publishers can go ahead and do that. I see that we have only 5 minutes left in the meeting, so I'll stop here. In case there's any further questions, we can take those.
Great, thank you. Any questions from our members, please raise your hand. So Aparna, starting with the IPR case, so basically content producers, musicians and whatnot, they're going to start receiving royalties directly from the radio stations. Is that how I understood that?
So the way it works, so IPRS will be collecting it on behalf of, so IPRS is a society, and it will only collect on behalf of its members. If someone is not a member of IPRS, then they can directly seek those royalties. But typically the way it works is IPRS or any other copyright society administering certain the rights of certain bodies, they will collect those royalties and then distribute to the authors. So that's how it works.
Are there set fees, or are they negotiated like a song's really popular, or has a higher fee?
So copyright societies, as per the law, the Copyright Act provides that they are supposed to publish tariff schemes, which is they publish those schemes, and the law also provides for now the Delhi High Court, the courts. Earlier it was the Copyright Board. It provides that the court will have to establish what the royalty is in case of a statutory license. So those are the two ways in which the royalty can be figured out.
Right. And since it moved from the copyright board, which was national, to the regional high courts, are there going to be different decisions in different high courts depending on where the music is played or where the content is generated, or is one court ruling going to have national implications?
Yeah, no, that's a very interesting question, and I don't know if anyone has till now thought about that, because there was, so what happened was, so a part of the background that I did not give in the interest of time was that before the Delhi High Court decision, IPAB, which was then the Copyright Board, had passed an order setting the royalties, and then post the IPRS decision, the Delhi High Court decision, there was a petition before the Delhi High Court asking the Delhi High Court to set new royalties now that the IPAB had been abolished. But the Delhi High Court asked to directed to maintain status quo and keep paying as per the IPAB orders. But yeah, it's yet to be seen how it's going to be figured out. Which court will determine the royalties.
Thank you. And does broadcasting via the internet to the public count if I download a radio station on my smartphone, or is that included in this, or is it only terrestrial broadcast, traditional radio, AM, FM?
It is most likely included in this, yes.
Okay, great, thanks.
Yeah.
All right, I want to open it up to our members. Any questions on the issues that we have discussed today, or frankly, why we have some really great experts? Is there any other media and entertainment question you might have? Wonderful.
No question, just a big thank you for making this very clear, really helpful. Thank you.
Great. I do see a question. Thank you for that, Jared. I see a question from Vanita. Over to you.
Thank you, Jay. Hey, Aparna, thank you so much for the overview. Is there any movement on the statutory licensing bit? I know there were two court cases, one I think in Bombay High Court, the other one I think is in Delhi High Court, or Supreme Court. If you could just shed some light.
Yeah, so the Delhi High Court one remains pending. Nothing further there. In fact, in this judgment, the Bombay High Court has noted that nothing has moved on that bit. Yeah, I think it's just it remains pending. I think both of them. But yeah, we'll happy to update as and when there's something new that happens.
Thank you. Great. Aditya Kaushik, over to you, sir.
Thanks, Jay. Thanks, Aparna and Tanisha for the presentation. I have a general media and entertainment question. Last year, during the union budget, a task force was instituted to create, to sort of build out systems around AVGC XR. And I believe the Ministry of Information and Broadcasting was, the task of the task force was to figure out, to sort of push for Create in India campaign and to look at domestic production of talent and content in the world of AVGC XR. So I just wanted to sort of understand how would the interministerial collaboration work out, or if you have any thoughts or ideas about it, because someone mentioned about the growth of the gaming industry, and in terms of talent and skilling and so on. Do you have any ideas or thoughts around it? Do you think there are any conversations that are happening around this?
Honestly, I would not have an idea on this. I don't know, Tanisha, if you have anything, because we were tracking the AVGC report and so on this aspect.
You're on mute, Tanisha.
Sorry, I didn't realize I was on mute. Yeah, so the AVGC task force reports have come out, and what happened basically was that they set up several subcommittees to focus on specific verticals within AVGC, right? There was a separate sub-task force for gaming, a separate one for comics, etc. And if you see, basically the bulk of recommendations in the AVGC task force report, and we at this stage don't know which of those recommendations will be taken up or not, right? Because it was just a like recommendatory in nature. Basically, the focus, I think, in the overall report has been on education and on skilling, to improve skilling, especially in the arts, to make India a global production house, and for Indian origin content to reach the global stage. To put it, absolutely in a nutshell. Though there are some, specific recommendations as well, which are industry wise, vertical wise.
Wonderful, thank you. A question for Subi, but before we go there, can we please do something on comics? If you guys have any clients that are content producers of comics or graphic arts or anything like that, graphic novels, I think that would be a really nice piece to kind of educate our larger community on, something we don't typically talk about in media and entertainment. So, Subi, over to you, ma'am.
Jay, I just want to add to what Aditya asked, and it's a really important question because a lot of others have been grappling with it. So Tanisha is right when she says that AVGC committee was interministerial, and I was invited as one of the subject matter experts, but they did not want to touch regulatory at all. So Aditya, long answer to your question is line ministry remains MeitY. Again, INB did not want to get into gaming or content issues. They're happy looking at rating, they're happy looking at content per se, but when it comes to technicalities, they did not feel that they were the right ministry. So the questions that they asked and they wanted us to respond to were of a recommendatory nature, where they wanted to look at global collaborations, IPs that you can co-create, and how do you really create an ecosystem, which is more from the long tail impact of things, but no immediate recommendations or frameworks that you could look at for ministries. Jay, also another suggestion which extends into comics, opinion trading platforms are also very, very keen. And they're a new, very, very interesting segment. Plus, there's great understanding and maturity in the US as far as regulatory frameworks are concerned. India's evolving. So a couple have reached out. That would be another segment that we should certainly look at.
Great, thank you for that. That's a great idea. Well, with that, I'll give our members one final opportunity for questions. Going once, twice. Husefa, if you could come on the screen. I really want to thank our Nishith Desai experts. Really appreciate the time and forethought you've put into this. We look forward to doing more of these. I'd also like to thank our members for engaging in the conversation and asking really great questions. It's very much appreciated. If there are other topics or issues you want us to address, please let us know, drop us an email. I'm happy to connect you with the Nishith Desai experts as well. Of course, prior to our next quarterly update, if there is a new policy of importance, we would look to the Nishith Desai team to do one of our rapid response webinars. And with that, let me thank everybody for their time and attention, and have a great evening, morning, or night, depending on where you sit. So thank you again, and goodbye.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Thank you all.